Hello everyone, hope you have an amazing day and welcome to my new blog. Today our topic is labor policy and laws in India. So different government have different development goals for their economy. Generally, these include a faster growth of national income, alleviations of poverty and a reduction of income inequalities. But how is industrializations expected to contribute to these goals? The experience of industrial economics shows a close association between development and industrial expansion. And industry is deemed to provide certain things which benefit other activities also, such as enhancement of skills, training of managers, dispersions of technology, etc. Moreover, the prospects of foods and raw materials made the situation of domestic for imported manufactured goods seem the most promising route to develop many countries most advanced economic progressed from the green revolutions to the industry revolution and then on to the service revolutions. So India, however, flew over the industrial revolution. It jumped from the green revolution straight to the service revolution. The first industrial revolution was steamed power, the second electrical. The birth of the computer age marked beginning of the third revolutions, and the fourth, which come argue is just a continuations of the third, is the era of the wearable gadgets, 3D printing, machine intelligence, and network devices. India has said the fourth industrial revolutions will add unpredictably to the future of work, requiring people's opportunity also and well-being to the localized and re-examined. Now, industrial revolutions and industries, India's labor policy. Labor rights or workers' rights are a group of legal rights and claimed human rights having to do with labor relations between workers and their employers, usually obtained under labor and employment law. History of industrializations encompasses a constant struggle between labor and capital. So capital has been exploiting the labor to the maximum benefit. It is generally expected that solving labor problems is a major responsibility of the government of any country, particularly a non developing country. Hence, the government is vested with powers to enact and implement labor laws for solving problems not only of labor but also for the management. After independence, the cost of living has increased considerably. The increase in the cost of living and countrywide political upsurge found its way in economic discontent among the masses, particularly in the industries, the industrials unrest and economic discontent led to a number of strikes and labor troubles, as you all know. Workers were generally uh, illiterate and poor and unaware about their rights. Workers are weak and negotiating with employers for employment and wages. So the employer dictated their own terms and conditions regarding wages and employment. The worker, being in weaker position, have no choice but to accept such terms for employment because employment was the only means to earn their livelihood and feed their family. So, uh, so they accept these offers. So, on the other hand, without considering the paying capacity of the management, there is a constant demand from laborer for revisions of wages and allowances, even though it may not be in a position to fulfill workers' reasonable expectations about wages, working conditions, and welfare facilities. So, why there is a need for labor legislation? The relationship between the workers and employers is one of the partnership in the maintenance of the production and building up of the national economy, and therefore of utmost importance. The community as a whole, as well as individual employers, are under an obligations to protect the well-being of workers and to secure to them their due share in the gains of economic development. The individual workers are economically weak. They cannot bargain with the employers for the protections of their rights and even for substance wages. As such, legislations for the protection of labor against long hours of work and unhygienic working conditions, low wages, and exploitation is required. In order to increase the bargaining power of labor, legislation is necessary to encourage the formation of trade unions also. In order to avoid industrial disputes which lead to strike and lockouts, labor legislation is needed. The workers are exposed to certain risks in factories, mines, and other establishments also. As such, in order to make provisions for their health, safety, and welfare, legislation is needed to protect children and women from taking to work under hazardous conditions and at odd hours and in hazardous processes. Laws are necessary. Twofold object of labor legislations to improve the service conditions of industrials labor so as to provide for them to ordinary amenities of life, to bring about industrial peace which could in its turn accelerate productive activity of the country, resulting in its prosperity also. For the aforesaid reasons, labor welfare is one of the major aspects of the national program toward the improvement of the majority of labor. The government has devised various rules, legislations, and acts for the protection of their rights. Labor policy in India has been evolving in reason to specific needs of the situation to suit the requirements of planned economy, development, and social justice, and has twofold objectives, namely maintaining industrial peace and promoting the welfare of labor. The second and the third and fifth 5 years plan emphasized to recognize and implement the schemes of workers' participations also. Now, labor policy under the second 5 year plan. The code of discipline in industry was accepted voluntary by all the organizations of employers and workers, which has been in operation since the middle of the 1958. The code laid down specific obligations for the management and workers with the objective of the promoting constructive operations between their representatives at all levels. As a result of these new concept of such far-reaching aims, there has been considerable improvement in the sphere of industrial relations. The number of many days lost declined significantly from 47 lakhs during January to June 1958 to 19 lakhs during July December 1960. The code provides that every employee shall have the freedom and right ever to join a union of his own choice. Further, a form of workers' participation in management was evolved. Joint management councils were established on an experimental basis. So, the council was to bring about mutual consultations between employers and workers over many important issues which affect industrial relations. Also, a scheme of workers' educations was implemented. The scheme comprised training of teachers, administrations, and workers' teachers. These schemes has helped to raise the self-confidence of workers and has increased their ability to take advantage of protective labor law. So, labor policy under the third five-year plan. The labor policy was designed according to immediate and long-term needs of a planned economy. And India's present labor policy is directed toward that attainment of full employment and assisting standard of living of the people. So the concept of the socialist society was kept in mind. Hence, as pointed out in the third five years plan, the fruits of progress should be shared in an equitable manner. So the labor supply protections contained in the five-year plan, fifth plan, I mean to say, and imply an increase in these labor laws about 18.26 million. Hence, the plan is oriented towards substantial employment opportunities also. Now, labor policy under Constitutions of India, Article 43A. Further, the Constitutions of India under Article 43A inserted by 42 Amendment Act 1976 opened a new perspective in industrial relations in modern India. It enumerates for the participations of the workers in management of industries. It states that the state is duty bound to take steps by suitable legislations or in any other way to secure the participations of workers in the management of the undertakings, establishments, or other organizations engaged in any industry. Labor legislation has grown up as one of the most important social institutions in India. A quest for industrial harmony is indispensable when a country plans to make economic progress. It may be platitudinous, but it is nevertheless true that no nations can hope to survive in the modern technological age. Such less become strong, great, and prosperous unless it is wedded to industrial development, to technological advance. The various legislations includes the Factories Act 1948, Payment of Wages Act 1936, Industrial Employment Act, Standing Orders 1946, Workman Compensation Act 1923, the Trade Unions Act 1926, the Minimum Wages Act 1948, the Employment State Insurance Act 1948, the Employees Provident Funds, Family Pensions Funds and Deposit Linked Insurance Funds Act 1952, sorry. Now, labor policy under the Labours Act 1948. Section number 41 of the Factories Act 1948, inserted by amending Act 1987, provides that the occupier shall in every factory where hazardous processes takes place or where hazardous substances are used or handled set up a safety committee consisting of an equal number of representatives of workmen and management to promote cooperations between the workers and management in maintaining proper safety and health at work and review periodically the measures taken in that behalf. The Factories Act lays down that the woman cannot be employed in the right night shift, and the Mines Act also prevent employers from making women work underground. In the case of children, the Factories Act lays down that those below age of 14 cannot be employed in factories. Moreover, above 14 who are employed cannot be given work for more than 4 hours, 4.5 hours a day. And pregnant women were to be given for 4 months of maternity leave with full pay for the leave period. The employers have to provide for the crèches of the workmen for the children of working mothers. Labor policy under the Industrial Disputes Act 1947. According to sections 2 RA of the Industrial Disputes Act 1947, unfair labor practices refers to any of the practices specified in the fifth schedule to the Industrial Disputes Act 1947. According to the section 25T of the Industrial Disputes Act 1947, no employers or workman or a trade union, whether registered under the Trade Unions Act 1926 or not, shall commit any unfair labor practice. Further, sections 25U of the Industrial Disputes Act 1947, any person who commits any unfair labor practice will be punishable with imprisonment for a term which may extend to 6 months, or with fine which may extend to 1000 rupees, or with both. So, the labor policy under the bonded labor system, Abolitions Act 1947, the Bonded Labor Systems Abolitions Act 1947 abolished the bonded labor system all over the country, and this act envisaged release of all bonded laborers and the simultaneously liquidations of their debts. The new 20 points programs stipulated full implementations of the laws abolishing the bonded labor systems, which implies identifications, release actions against offenders, constitutions of the holding of regulations, meetings of vigilance and committee at district and subdivisional levels, etc., with a view to supplementing efforts of state government. Centrally sponsored schemes has been in operation since 1978 or 79, under which state government are provided central financial assistance for rehabilitations of bonded labor. Though the government has made this act for the workers, the implementations of labor welfare and security schemes is not satisfactory. So that's for the video, my friends. Thanks for watching my video. Please subscribe my channel and also share and comment on my channel. Thanks a lot for watching.